A very good afternoon to all of you friends. A very good afternoon to all of you. On behalf of BYJU'S Exam Prep, the most comprehensive preparation app for all exams, I, Shurojit Bhaduri, welcome each and every one of you for today's live session on legal reasoning practice question. So we bring to you this very important series, keeping in your mind that you have a CLAT 2022 very close to you. Now, apart from CLAT, also you must be preparing for Maharashtra CET, ALET, SLAT, BLET, Jamia. So a student who is preparing for a law entrance examination, of course, the best would be CLAT and ALET. But apart from CLAT and ALET, people do sit for various examination. So friends, today we bring to you certain very important legal reasoning questions for SLAT symbiosis. There are 4 campuses of symbiosis, BLET, Jamia, and other host of examination like Maharashtra CET. I'm sure that a lot of you are from the state of Maharashtra and you guys are eagerly waiting to join GLC Mumbai or ILS Pune for that matter, right? So keeping everything in mind, we bring to you this very important session on practice legal questions. Okay, so let's get started, guys. Let's get started. Okay, I would request all of you to share this session with your friends. Okay, so guys, let's get started. Okay, let's get started. I think the answer is also coming. Okay, the answer coming. Okay, just read the principle and the facts and just try to hide the the answer. Okay, read the thing and tell me what is the correct answer to this question. Okay, so parties to contract can only lay the foundation of a valid contract if the parties are capable of entering into a contract. Now, the first thing that should come to your head is a 17-year-old boy. A 17-year-old boy. He happens to be a minor. The law of contract very categorically states that a minor cannot enter into an agreement unless it is for necessary goods. Now, a Ferrari is definitely not a necessary good. Okay, so the correct answer is yes. Option B. This is a void ab initio contract. This contract is void ab initio. From the very birth of the contract itself, it is void. Moving on to question number 2. Read the question very carefully. Okay. Yes, tell me, what is the correct answer? The correct answer is option C. Zinab will succeed because Lakshita did not have reasonable justification to make that statement. What statement? Lakshita posted on the social media by calling Zinab talentless and she does not deserve to stay in the industry. After this, Zinab files a suit for defamation against Lakshita. Is that clear? Is that clear to everyone? Very good, very good. Moving on to question number 3. Okay, yeah, please give me answer. Now the contract exists between P and R. The contract exists. Is there any contract between P and Q? No contract. What does the principle say? What does the principle say? Parties to a contract are bound is liable. So the correct answer is there is no legal remedy because there is no contract between P and Q. No contract exists between P and Q. Is that clear, beta? Every one of you. Question number 4. Okay, tell me the correct answer now. So there is misrepresentation in the present fact, and the principle says that a contract obtained by misrepresentation is voidable in the option of the buyer. So the correct answer is the contract is voidable on account of Sunil's misrepresentation because Naren did not have the diligence required to discover the truth. So the correct answer is option D. Is that clear? Most of you gave me the right answer. Yeah, Madhavan, Kiza, very good. Muskan, Bano, Shrishti, very good, very good. There are 2 Shrishtis now. Okay. Moving on to question number 5. Now they're under absolute undue influence. Here is a man who is under that impression that he is signing as a witness, he signs it as one of the parties. Will Girish be liable? Let's see what the correct answer is. Let's see what the correct answer is. Of course, Girish is not liable. So option A also is over and C is over. So between B and D should be the answer. The correct answer is option B. Girish is not liable because he thought that he was signing a will as a witness. So the correct answer remains option B. Am I clear to each and every one of you? Am I clear to each and every one of you? Are you understanding? सभी को समझ में आया? Is that clear to everyone? Any doubt? Okay. Moving on to question number 6. Now, before the shopkeeper can agree to the offer, S makes another offer that he is willing to sell it, purchase it at 5,500, right? So for 5.5 grand, he makes an offer to buy it. And later on, can he refuse? He has made an offer. So he has to. The correct answer is option B. S is liable to pay 5,500 because it is a case of a counter offer and the first offer has lapsed because he made the new offer. Am I clear? Is that clear to each and every one of you? Am I clear? Okay. Before moving ahead, BYJU'S Exam Prep brings to you a crash course for CLAT 2022 aspirants. So if you are a CLAT 2022 aspirant and you have not joined any of the courses from BYJU'S Exam Prep, here is your final chance of joining this crash course for CLAT 2022. Get yourself enrolled for this course. The course has been launched. In this course, you get expert guidance by NLU alumni until the day of your exam, day-wise study plan covering the entire syllabus to help you score better, weekly performance test, faculty counseling and guidance session, and above all the topics will be covered through live classes and quizzes. The course is launched. Get yourself enrolled. Question number 7. If you know what is an invitation to an offer, the answer will be very easy for you. Now, can Miss Tanvi do anything about it? Now, what is an invitation to an offer? Here is a particular taxi. You see a particular taxi and you say that, okay, I want to go to X place. He says, no. You are making an offer to the taxi guy and saying that, to the cab guy and saying that, I want to go to this place for rupees 100. Are you agreeable? He says, no, I am not agreeable to it. He can definitely say that, because it is voidable at the option of the driver. This is what we understand as invitation to an offer. Am I clear? Everyone, each and every one. Is that clear to everyone? Okay. Question number 8. Read the principle very carefully. Law of tort, vicarious liability. For the wrong committed by the servant, the master is held responsible. Read the principle. The principle has the answer. Master-servant relationship. Keep that in your mind. Okay, let's see the correct answer. Okay, Abhinav says A, Gargi says B. Okay, Violet says B. Okay, Muskan Bano B. Okay, let's see the correct answer. The correct answer is Roman is not liable because there is no master-servant relationship between the police officer and the other person. Between Roman Gilchrist and police officer, is there any master-servant relationship? No. The police officer is sent to provide certain security. That does not mean he is under Roman Gilchrist. Now, police officer is a employee of the government. Okay, he's a government employee. Am I clear? State government employee. Now, he is sent to provide security at a wedding. That does not mean that the police officer becomes the servant of Mr. Gilchrist. Am I clear to everyone? Am I clear to each and every one of you? Because this is very, very important for you to understand. So the correct answer is no master and servant relationship between Gilchrist and R. There is no master and servant relationship. No. There is no master servant relationship between them. Is that clear? Every one of you. ऐसे questions आते हैं. Before moving ahead with the next set of questions, BYJU'S Exam Prep brings to you a comprehensive preparation course for CLAT 2023. If you are an CLAT 2023 aspirant, do join in for this particular comprehensive preparation course, batch 2, which has been launched now. Get yourself enrolled for this particular course. It's a very, very important comprehensive preparation course meant for students preparing for CLAT 2023. In this particular course, you get expert guidance by NLU alumni until the day of your exam, day-wise study plan covering the entire syllabus to help you score better, one-to-one mentorship, and weekly performance test. So guys, don't wait for anything else. Just get yourself enrolled for the comprehensive preparation course, batch 2, which has been launched on 3rd of March. Okay, so get yourself enrolled, and this is a very important batch for CLAT 2023 aspirants. So we have separate batches running for CLAT 2022 and separate batches running for CLAT 2023 also. Moving on to question number 9. Yes, unless and until there is a legal rights violation, unless and until there is a violation to a legal right, under law of tort, you cannot claim compensation. So only where a legal right is violated, you can claim compensation under law of tort. Now you have to answer this question. Which legal right has been violated in this particular case? Which legal right has been violated? Has Farhan's legal right been affected? No. Now, Farhan might have suffered financial loss. Farhan might have suffered financial loss. But is there any violation of a legal right? Is there any violation of a legal right? The answer is no. Since there is no violation of a legal right, you cannot claim compensation. Very good. The correct answer is option B. Very good. No, Farhan cannot claim damages from Samir because Samir established a school free of cost for the children. Now there might be, sorry, I got it wrong. Farhan cannot claim damage because only it has caused financial loss and no loss to his legal right. So legal right, once violated, you can claim compensation. So the correct answer is option B. Am I clear to each and every one of you? Okay. Am I clear to each and every one of you? Any doubt? Okay. Moving on to question number 10. Yes, this is a case of a Gloucester Grammar School. Absolutely, Gargi. Gloucester Grammar School case. Yeah. Voluntary non-fit injuria. Keep that thing in your mind. There is a defense under law of tort called voluntary non-fit injuria, right? So what is it? You better know. So David went to a cricket stadium to see a match between Australia and England. Now it was the 35th over, whatever over it is. Now here is a man who hits a 6 and the ball hits on this David's head. Now this has caused certain injury to him. Now the moment you buy a ticket, to watch a game, you know that you are going to the stadium. Now you know very well that in a cricket match, somebody might hit a 6. It is not very unusual that people hit a 6. Very regularly people hit a 6. So when you buy that ticket, itself of seeing or witnessing a cricket match, you know the risk involved in going to the stadium. If you know the risk involved and you have participated in that risk, you cannot claim compensation for an injury that is caused to you. So the correct answer is option D. He cannot claim compensation because he agreed to the injury. Voluntary non-fit injuria. Is that clear to each and every one of you? Am I clear to each and every one? Okay. Are we clear? Did you all understand? Fantastic. How much did you score? How much did you score? Tell me. Give me the numbers. How much out of 10? Kitna mila? Out of 10, how much did you score? Tell me. Okay. Okay. Many congratulations. Many congratulations. So friends, a very important announcement. BYJU'S Exam Prep brings to you also an express course for Maharashtra CET, A-Lit, SLAT, B-Lit and Jamia LLB 2022. So apart from CLAT, if you are preparing for Maharashtra CET, A-Lit, SLAT, B-Lit or Jamia, these questions were very important for you. So with this friends, we come to the end of today's session. Thank you very much. God bless you. Stay home, stay safe, stay healthy. Have a great day ahead. Thank you. All the very best. All the very best, guys. All the very best for you. Bye-bye. See you.